Good afternoon, everyone. I'm Jasmine Zulkifli, G25 Malaysia's Executive Secretary and Edunity Foundation's Project Manager. On behalf of G25 and Edunity Foundation, I'd just like to welcome and thank all of you for tuning in today to our webinar on the importance of institutional reforms post-COVID-19. For those of you who are new to G25, the group was founded in December 2014 with a letter addressed to the people of Malaysia. It basically addressed issues regarding the administration of Islam in our country. Subsequently, G25 became more involved in matters relating to institutional integrity and accountability. For your information, Edunity Foundation is the corporate organization of G25. This will be our 6th webinar this year. We started off the year with 3 webinars focusing on seeking solutions for the COVID-19 crisis. This included the management of the pandemic and also looking into the problems faced by our prisons and vulnerable groups such as our refugees and foreign workers, among others. In March, we delved into the educational challenges we've been facing during these COVID times, and in April, we discussed freedom and tolerance in Islam. If you missed any of our previous webinars, don't worry. You can still check them out on our website, edunityfoundation.org or g25malaysia.org. Links will be in the description box. Today, we have 4 highly distinguished guests on our panel, each an expert in their own right with accolades to their name. They will be giving us their take on the different aspects of institutional reforms, the importance of which is something which G25 has been promoting for years as a means for ensuring good governance, stability, and confidence in the administration of our country. Our panelists today are Tan Sri Rebecca Fatima Stamaria. She's the former Secretary General of the Ministry of International Trade and Industry, and she is now the Executive Director of the Asia Pacific Economic Cooperation Secretariat, or APEC Secretariat, which is based in Singapore. We have Datuk Sri Muhammad Hishamuddin Yunus, who is a former judge of the Court of Appeal and also a member of G25 Malaysia. We have Emeritus Professor Datuk Dr. Syed Salim Faruqi, who is a Malaysian legal scholar and professor of constitutional law. And we have Tricia Yeo, who is the Chief Executive Officer of the Institute for Democracy and Economic Affairs, or IDEAS for short, which is one of the premier think tanks in our country. Moderating today is G25's very own Tan Sri Muhammad Sharif bin Muhammad Qasim. As a former high-ranking civil servant, Tan Sri Muhammad Sharif is one of G25's original 25 founding members. Tan Sri Muhammad Sharif is also chairman of Edunity Foundation. At the end of the panel session, Tan Sri Muhammad Sharif will be taking questions from our Slido page. So if any one of you at home have any questions that you'd like to direct to the panelists or even to our moderator, please feel free to go to slido.com and post your questions there. To do that, open a new window on your internet browser, type in slido.com, that is slido.com, type in the event code #G25 and post your questions there. We have written the steps in the description box so that you can refer to it easily. Now, without further ado, allow me to pass the mic over to our moderator. Tan Sri Muhammad Sharif, the floor is yours.
Thank you very much for the initial introduction from Jasmine, our Executive Secretary in G25, and also our Project Manager in Edunity Foundation. For your information, Edunity Foundation is the corporate identity of G25, so it's supposed we are part of. In corporate terms, we are under Edunity Foundation. I thought I will start off by making my own statement, which will introduce broadly the subject that we're discussing today, corporate governance. So I'll take about 6, 7 minutes. And then after that, we can start the discussion. So welcome everybody. Good afternoon. And thank you for the speakers, the panel speakers. So let me just say a few words. The need for institutional reforms has long been advocated by various civil society organizations and NGOs as important for ensuring good governance, to protect the country and the people against abuse of power, corruption, racism, and religious extremism. It is encouraging to hear the public demands for Parliament to be reconvened and for the state of emergency to end. The public clearly wants to see our system of parliamentary democracy to be restored, not for fun, but because it's a serious matter of making the government accountable for its handling of the COVID pandemic and accountable for the big expenditure under the National Recovery Plan. G25 has produced reports on several matters concerning the institutions of government and has presented our views in public forums and to the Institutional Reforms Committee set up by the Council of Eminent Persons during the administration of Pakatan Harapan. The presentations that we made to the Institutional Reforms Committee include the subjects which our webinar speakers today will be talking to you all. In fact, what you're going to hear today from them are the most important reforms that will make our country better governed and more respected domestically and internationally. We in G25, and I'm sure all Malaysians too, want to see our country become a progressive state and a model for other Muslim majority countries to follow. This aspiration was the impetus for G25 to conduct a study on the administration of Islam in the country. And because we saw with some trepidation the increasing trend of religious extremism, which can be a threat to our multi-ethnic, multi-religious society. In accordance with the principles of good governance, we have stated publicly that the administration of Islam should not go against the fundamental liberties as provided under the Constitution. Now, we already have a good economy with relatively high standards of living, but all the economic and social progress that has been achieved over the last 60 years will be wasted if we do not improve and strengthen our system of checks and balance to make our government and our administrative system respect the rights of all citizens, irrespective of race, religion, rich or poor. This will give real meaning to the objectives of creating a caring society for all Malaysians, as initiated in Malaysia's economic plan documents. In a democracy, the elected government comes and goes. But if the institutions are strong and the corruption is kept in check, the country will remain stable. with the institutions of maintaining law and order, with the institutions maintaining law and order, and upholding the supremacy of the Constitution and the rule of law, the country will continue to progress with prosperity and happiness for all Malaysians. Good governance with strong institutions is a must in normal times. With a crisis such as the one arising from the COVID pandemic, this becomes even more urgent because the structures and initiatives, such as the various forms of cash and other forms of aid that are put in place by the government to reduce the burden and suffering of the rakyat, need to be managed properly with diligence, honesty, and accountability. As part of good governance, political leaders must not only behave in ways that do not offend the rakyat, but they must be seen to do so. The breaching of SOPs and junkets overseas by some of them have tremendously angered the rakyat. And my final point has to do with the corporate sector. In the corporate sector today, the buzzword now is ECG, environment, social, and governance. These three ESG factors are being increasingly adopted by companies when they make investment decisions, because more and more company boards and CEOs realize ESG is important for long-term sustainability of their growth. Our top GLCs are also becoming more committed to ESG, especially the Khazanah Group companies. Good governance in the government sector will also lead to good governance in the private sector. Therefore, the government must now take the lead to strengthen its governance so that with integrity and accountability in government institutions, the whole country can develop to become a high-income country. That is all I have to say, and I hope that gives an overall picture of the topic today. And now, without further ado, let us go to the webinar discussion. May I call upon Tan Sri Rebecca to start to be the first speaker? Thank you very much, Tan Sri.
Thank you very much, Tan Sri Sharif, Prof. Shad, Datuk Sri Hishamuddin, and my friend Trisha, and all of you have taken the time to listen in. I want to begin by thanking the organizers for this kind invitation to be on this panel and to share it with folks I have so much respect for. This is indeed an honor, and I must state that my sharing here is in my personal capacity. The views expressed are those of a concerned Malaysian and do not necessarily reflect those of APAC or the organizations I'm associated with. May I ask Huda to please share my slides? Yeah, thank you. We'll go straight. Next one, Huda, please. Yeah, I'd like to start by sharing these two important quotes from the Malaysia Economic Monitor of 2019 and 2020. You know, this really sets the stage for my presentation about the civil service. The first one says, while Malaysia's public service perform well and at par with regional standards, its performance has been largely stagnant and falls short relative to high income aspirational comparators. And the next one is really what we should be looking at today, looking at into the future to seize new growth opportunities and overcome potentially long-lasting challenges brought on by the pandemic. We should consider bold structural reforms, and I think that's the core of what we'll be discussing today. My outline is simple. Next slide, please. We're looking at I will spend some time on our North Star, what I think is the North Star for the civil service. Been there, done that sort of captures all the things that we've done in the civil service. Lessons from the pandemic and getting to tomorrow today. Next, please. This, my North Star, our North Star civil service. At the outset, I want to recap the North Star for all civil servants. For 35 years, I was a Malaysian civil servant, and I have an interest, the interest of this group of Malaysians at heart. So I know that my colleagues in the service are facing huge challenges. So my comments are meant to be constructive. First, our raison d'etre is to serve the people. We are first and foremost servants of our society. Our responsibility is to serve with integrity, respect, and acceptance of the diversity within our society. Our role is administration, policy formulation, and implementation. And the focus has to be on the country, towards our progress and development. I'm recapping this because I feel that it has to be said and it's important. Our ethos is to be politically neutral and professional, impartial and collaborative. There are questions around these points that I've just flagged, but we must keep in mind that these points are, towards our North Star. Next, please. So, been there, done that. This is what is said. We have a whole lot of initiatives and programs that have been put in place, starting in the 90s and 80s, even the 70s. The Total Quality Management, Malaysia Incorporated, Looking East, MS-ISO 9000, Clients Charter, all this. And the latest, I know that was recently launched, the Digital Regulatory Notification. This is part of the initiative to have more digitalization in the service and to make it faster and quicker to respond to engagement with our clients, with the Malaysian public. Now, so what it says is that we have been continually striving for improvement. The list here is non-exhaustive. These are things that we've tried to do, but the ultimate goal is to ensure that we work as a team, focus on service delivery, transparency, governance, and predictability. Clearly, much has been done to provide the tools to achieve these goals. It's really up to each generation of civil service leaders to integrate these initiatives and not let them be seen as standalone flavor of the moment events. We need to integrate. These are good ideas, but they cannot be just treated as events. And unfortunately, sometimes this is what happens. I mean, the whole exercise of good regulatory practice has as its core engagement with our public. That we don't formulate regulations without engaging. That if there are guidelines that we've put in place, now the only thing is we need to be true to these guidelines. We need to implement this in its fullest. I have friends in the service. I know at the National Productivity Corporation, they've been working tirelessly to get this, but it cannot be done by one body. It has to have the whole of government engagement of everybody and everyone must be committed to good regulatory practice. I mean, if we did all these things, we won't be where we are now. I mean, unfortunately, we have to take this in its right spirit and not as flavor of the month or flavor of the moment events. Next, please. So what has the pandemic taught us? What are the lessons that we've learned? Clearly that we need the sense of urgency, determination, speed. We need to prioritize. We have rigid systems, and we've seen it, how because of our rigid systems, lengthy procurement or recruitment processes, this has really got us into a bind. And the protest that we had yesterday by the contract doctors, I mean, that saddens me to see it. This is clearly something that we need to focus on. We need to see how this is a priority. Health, this is a health crisis, right? As a nation, we've gone through a host of challenges. However, this pandemic sees us having to cope with not just the double whammy of a health and economic crisis, but I call it a triple whammy, with a political challenge thrown into the mix. in such an environment, the role of the civil service is even more important. As Tan Sri Sharif said, elected governments come and go, but the civil service remains, ensuring policy continuity. As I stated in the beginning, we must be guided by our North Star. Understand what is our raison d'etre, to serve the people, to serve our society. We must deal with the perception of lack of coordination. You get different news coming on social media. Managing social media is a big thing for us. We have to learn to do this. This is a lesson from the pandemic. Get your social media skills in order. Listen, because people are communicating with us through social media. Don't block comments from people, no matter how much we dislike those comments. In the spirit of engaging with our people, with our public, we have to listen, and therefore do not cancel your comments. The comments from the public is what will help us to grow and to change and to make those structural changes that we need to do, that we need to put in place. There is a trust deficit that goes without saying. So it's up to us, the civil servants, to build that trust again. And one way is to really engage our public, and I'll speak to that in a little bit more. The whole process of transparency and engagement to deflect all this confusion. Our role as civil servants is to advise. So provide the advice about making sure that SOPs or instructions, guidelines are one and the same, consistently shared with the members of the public. This perception of lack of coordination is really a challenge, and that needs to be dealt with. Next slide, please. So this is my last slide, but I want to spend a bit of time here. We have to make the changes. The post-COVID will not be the same as the pre-COVID. We as civil servants, our position is so important. We have to perform at par with regional standards. I think that's so important. We have to look at our institution. Go back to your North Star and say, what is your guiding principle? Go back to those true values. We need to relook our recruitment processes. It's cliche but true. We all have a part in this, in finding the solution to this. The pandemic has exposed systemic weaknesses in our system. So we cannot go on as if it's business as usual. If we do not make the changes, it will be a missed opportunity. This is a good time as any for reform. When we look at recruitment, for example, the civil service, we are the policymakers. We must improve our recruitment policy, ensuring that it is based on meritocracy, inclusivity. The whole idea, the whole reason, if you look at what happened yesterday, the doctors going protesting, that is a systemic problem. It's been there, it's been brewing, but we didn't pay attention to it. And then it's brewing and brewing, and now it has surfaced. So we need to relook our schemes of service to ensure that our system is agile enough to deal with the needs of the country. So the contract doctors is just one case in point. There's a lot more there. Finding a scheme of service that is not so rigid, whether it's for the teachers, the nurses, the doctors, the engineers. These are things that we must confront, we must deal. And this is the time we have the opportunity to do it, we should do it. If we do not make the changes, it will be a missed opportunity for us, seriously. The civil service, as policymakers, we must improve our recruitment process, as I said. You must base it on meritocracy, inclusivity. We have to rethink the skills that we need. When you took of the skills that we will need in this new environment, it is a different, we are dealing a lot more with the digital environment. So when you think of that, you then need to look at institutions that we have. For example, INTAN, the Institute of Public Administration. It was established in 1972. Clearly, we saw the need for it then. We have MAMPU, established in 1977. Now, the whole thing is these are bodies that were established to build the professionalism and help us to upgrade the civil service. So go back to these institutions and see whether they need to be changed, whether we need to revamp and make them modern, bring them to the 21st century, things like that. I mean, you have institutions, use them. We have to, this is my thing, we have to look at recalibrating some of our policies of, for example, education with the digital world, one, with the challenges that we have faced because of the pandemic. Clearly, we cannot go on as we have in the past. So time to do all this, to recalibrate, to look at the curriculum, to look at our HR policies, build our infrastructure, our digital infrastructure, take the whole of government approach. I know that there are parts of government doing what they can to deal with this pandemic, but we cannot go on like that. We need to have a more integrated whole of government, whole of Malaysia approach when we're dealing with the situation going forward. Look at federal state administration, look at interdepartmental relationships. We have mechanisms. We have the KSN chairing meetings monthly with all of the KSUs and heads of service. Here's the opportunity to really strengthen that body, to make sure that we speak with one voice and we have that engagement with our people. The voice and partnership must prevail. We must be open and transparent. It's important to have the ear to the ground. And I said, I talked about social media. Yes, this is the new world. We need to be adept at teasing out feedback and noise, differentiate feedback and noise, constructive feedback from just nuisance noise or mischievous noise. We have to be able to do that. That's a skill again. So having your ear to the ground, managing the trust deficit, this no wrong door, taking it further, especially in a digital world and with all the pressures that we cannot have our clients going from department to department. We cannot expect that they know that today they have to go to the police first and then get a license and then go to Bandaraya and get another license. It doesn't work like that, or go to MITI for another license. We have to figure out how we can have one point of entry for people. We cannot have industry going from door to door. So our role as the civil service is facilitating. So we have systems in place to do this. We just need to implement them. Communications, I talked about communications already, and keeping, engaging, managing the perception that we have, that people don't trust us. We have to start engaging. We have to start communicating, being more transparent with the way we deal with information. And the future, we have I saw the launch of the fourth industrial revolution recently. Well, it cannot again be an event. We have to integrate that into our systems. We have to make sure that we are all fair with dealing with technology, that technology becomes inclusive and sustainable if we're going to have a recovery which is meaningful for all of us post-COVID. When you think of the digital economy, think of the digital infrastructure and how it can be, the digital world can be very inequitable if we do not handle it properly. Recall the little girl who had to go up this hill in this mountain in Sabah to get internet access. So those are things that should, move us as civil servants to make those changes that we need to do. That's within our ability. That's within our power to do so. Keeping again in reminding ourselves of our North Star. We are here to first serve our people, serve the society. We have to be politically neutral and professional, impartial and collaborative. We work on policy formulation and implementation, most of all focusing on the needs of society, accepting of diversity within our society. On that note, Tan Sri, I end my presentation. Happy to take questions later.
Thank you. Thank you, Rebecca. Tan Sri Rebecca. For the information of panel members, there's already a comment that the need for reforms is obvious. How do we make it happen? I think we should address that issue later in the discussion during discussion time. May I call upon the next speaker, Datuk Sri Muhammad Hishamuddin Yunus, a former judge, now a G25 member. Datuk Sri.
Thank you, Tan Sri. Salam sejahtera. Good afternoon. Moderator yang berbahagia, Tan Sri Muhammad Sharif, members of the panel, ladies and gentlemen. First and foremost, I would like to congratulate Edunity Foundation and G25 for organizing this webinar. And I would like to thank Edunity Foundation and G25 for inviting me to be one of the panel speakers. I've been requested to talk on the topic judicial reforms in Malaysia and independence of the judiciary. I've narrowed down the scope of my presentation, focusing more on the appointment of judges in our country. I'm sure members of the audience will agree that judicial independence is very important for any civilized country that truly believes in a system of governance based on the principles of the rule of law. It hardly needs stressing that in any country, if there is no rule of law, there is bound to be anarchy. For the rule of law to exist in any country or government that practices parliamentary democracy, there must be an independent judiciary. That is fundamental. An independent judiciary is a crucial feature without which there can never be rule of law. In Malaysia, we subscribe to a system of government based on the principle of the rule of law. This is embodied and reflected in the Federal Constitution and the Rukun Negara. Now, talking about the independence of the judiciary this afternoon, I propose to first discuss how our Superior Court judges are appointed. By Superior Courts, I mean the High Court, the Court of Appeal, and the Federal Court. Among the process in place to enhance judicial independence, the law requires that candidates for judicial appointments or promotions are nominated by an independent commission called the Judicial Appointments Commission, known by the acronym JAC. From now on, I'll use the acronym JAC. The JAC was established in the year 2009 by an Act of Parliament, namely the Judicial Appointments Commission Act 2009. Credit must go to the Prime Minister then, Tun Abdullah Ahmad Badawi, for the passing of this act. This act was enacted following the finding of a Royal Commission of Inquiry into the video clip scandal, evidencing an inappropriate conversation that took place between a prominent lawyer and a very senior judge, namely the then acting president of the Court of Appeal, who later became the Chief Justice. The Royal Commission called witnesses, including a former Prime Minister, 3 former Chief Justices, a former Secretary of State, a prominent businessman, and a prominent lawyer. From the testimonies gathered, the Royal Commission of Inquiry made a startling discovery. And what is that discovery? It is that elements of political patronage were involved in the appointment and promotion of judges. And this is detrimental to the judiciary. And now I come to the composition of the JAC. The JAC comprised of 9 members. That is to say, firstly, the 4 top judges, namely the Chief Justice, who chairs the Commission, the President of the Court of Appeal, the Chief Judge of Malaya, and the Chief Judge of Sabah and Sarawak. These 4 top judges are automatically members of the JAC by virtue of their respective offices. Then, in addition, there are the 5 appointed members of the JAC. They are all appointed by the Prime Minister. First, the PM appoints a federal court judge to the JAC. So now there are 5 current judges who sit as JAC members. In addition to these 5 judges, there are what the Act calls, I quote, the 4 eminent persons. These 4 eminent persons are also appointed to the JAC by the Prime Minister. The role of the JAC is to nominate names of suitable candidates to the Prime Minister to be appointed as Superior Court judges. It is important to appreciate here that the role of the JAC is only to nominate or recommend names. This role is spelled out in sections 21 and 26 of the JAC Act. Please do note that the JAC does not appoint judges. Next, we have section 28 of the JAC Act that requires the PM, in a case where he has considered and accepted the name or names recommended to him, to tender his advice to the Yang di-Pertuan Agong in accordance with Article 122, capital B of the Federal Constitution. This section 26 of the Act will then have to be read with Article 122 B of the Federal Constitution. One needs to really understand this part of the law, that is, the interaction between an Act of Parliament and the Federal Constitution. Now, according to Article 122B of the Federal Constitution on the appointment of judges, His Majesty the Yang di-Pertuan Agong is constitutionally obliged to act on the advice of the Prime Minister after consulting the Conference of Rulers. The role of the Yang di-Pertuan Agong is merely a formality in that His Majesty must appoint whomsoever the Prime Minister has advised. Now I move on to the crux of my talk this afternoon. I have some reform proposals which may improve judicial independence. Number 1, the JAC Act is a mere act of Parliament. The JAC Act of 2009 is a mere act of Parliament. However, and this is the strange part, the essential provisions relating to the appointment of Superior Court judges are in the Federal Constitution. For example, just to take one provision, under the Federal Constitution, judges are appointed by His Majesty the Yang di-Pertuan Agong on the advice of the Prime Minister after consultation with a Conference of Rulers. Article 122B, which I've mentioned several times earlier. Thus, we have a situation where some provisions relating to the appointment of judges are found in the Federal Constitution, and some other provisions relating to the same are found in an Act of Parliament, and a law that is of a lower status as compared to the Federal Constitution. This kind of legal arrangement is very unsatisfactory. It may lead to problematic constitutional and legal issues. In my view, ideally, the main provisions of the JAC Act and the mechanism of appointing judges should have been incorporated into the Federal Constitution itself. Number 2, appointment by the Prime Minister. 5 members of the JAC, as I mentioned earlier, out of 9, are appointed by the Prime Minister. Again, this is unhealthy as the Prime Minister is not only a politician but head of the executive. There is a risk that he will not appoint independent-minded commission members, but he will only appoint members that are pro-executive or sympathetic to his political party. Thus, the system of appointment of the appointed members of the JAC needs to be reviewed. In my view, the appointments should be through open competition, like as practiced in the United Kingdom. In the United Kingdom, out of the 15 members, 11 members are appointed through open competition. In other words, they are not directly appointed by the executive. Point number 3, the commissioners may be removed at any time without reason. Under our JAC Act, the Prime Minister may at any time terminate the appointment of an appointed commissioner without giving any reason. Thus, an appointed commissioner does not enjoy a security of tenure, whereas in the United Kingdom, it is not that easy to remove a commissioner appointed through open competition. There, the UK government may recommend to His Majesty the Queen to remove a commissioner only for certain specified reasons. Number 4, composition of the JAC. Judge heavy and lacking in diversity. As I pointed just now, out of the 9 members of the JAC, 5 are serving judges. The 4 non-judges are the 4 eminent persons. But again here, there is nothing to prevent the Prime Minister to appoint ex-judges to be the eminent person, and this often happens. And there is lacking in diversity in the membership of our JAC. In my opinion, the membership should be expanded to have more members, say, for example, 15 members. There should be members to represent the bar, academia, attorney general, and there should be also lay members. Lay members, meaning members who are not legally qualified. The membership should represent the diverse nature of Malaysian society. We are multiracial, multicultural, and multi-religious. In the United Kingdom JAC, the chairperson has to be a lay person. In addition, there has to be 5 other lay members, whereas in our JAC, all 9 are legally qualified persons, not a single lay person. Number 5, Prime Minister not obliged to accept the nominated candidate. The role of the JAC is merely to nominate names of suitable candidates to the Prime Minister. Under Article 122B that I mentioned earlier, on the appointment of judges, His Majesty, the Yang Tan Agong, is constitutionally obliged to act on the advice of the Prime Minister. And okay, now, therefore, the person who effectively decides on the appointments or promotion of judges is no other than the Prime Minister himself. The Prime Minister may reject a nomination by the JAC, and he is not obliged to give a reason if he were to do so. This system of appointment is unsatisfactory and not conducive to the idea of an independent judiciary. This is because the Prime Minister is the head of the executive branch of the government. There are times when judges have to make decisions involving the executive or the legislature. Therefore, this arrangement, particularly on the role of the Prime Minister on the appointment of judges, does not accord with the idea of an independent judiciary. It gives rise to the perception that the members of the judiciary are beholden to the executive. It is suggested that a better method would be where the Prime Minister plays no role at all in the appointment of judges. It is proposed that the JAC, instead of the Prime Minister, recommends the names directly to the Conference of Rulers for their views, and thereafter directly to the Agong. In conclusion, it is my opinion that Malaysia needs judicial reforms pertaining to the method of appointing judges. If we desire an enhancement of the independence of the judiciary, the JAC Act has to be repealed and the federal constitution needs to be amended to incorporate provisions of the JAC Act, which in turn calls for some improvements, in particular with regard to the composition of the JAC and the role of the executive in the appointment of judges. Before I end, I just have this to say. We can have the best constitutional and statutory provisions and structure on the independence of the judiciary. But, and this is crucial for us to appreciate, such provisions and structure by themselves do not guarantee that we will have an independent judiciary. Ultimately, the level of judicial independence will depend on the judges themselves. Our judges must have the courage, honesty, including intellectual honesty, and the integrity to uphold the independence of the judiciary. With that, I end my presentation. Thank you.
Thank you very much, Dr. Sri. That's a very interesting topic, how to remove the political power behind the appointment of judges. I think that's a very important issue for us to discuss afterwards. Our listeners are already raising questions about, how do we talk about reforms on the civil service when there is no culture of meritocracy and diversity. I think Tan Sri Rebecca may want to bear that in mind afterwards. But I'd just like to say quickly that, although the comment seems to suggest that we have been talking about reform, but can we expect any progress? But there are real cases where there has been progress. I remember KSN, the old KSN, and Tan Sri Yong Pokong chaired a committee and it introduced a number of administrative reforms. I won't go into that because that will take time. But these reforms have been acknowledged, even in World Bank reports. It helps to make it easy for business to be done, at the land office, at the immigration, and I think that's true because today the queues are much, much, much less than what it was before. Parliamentary select committees, I think in the previous administration, they agreed to form 6 parliamentary select committees. And now I notice there is a big demand, and there is a big comment made by MP for Tuaran. He is complaining that 9 select committees are too few and he wants more so that all members of parliament can participate in policy making as he said. Separation of AGC, I think Takiuddin, the Minister for Law, mentioned that the government will study the proposal to separate the advisory function of the AGC and the prosecutorial function of AGC, something which G25 also took up before. So just to give some comfort to us all that although reforms are difficult, but there are glimmers of hope. So we shouldn't give up hope at all. Now, may I now come to Professor Datu Professor Syed Salim Farki. He will talk on parliamentary reform. So.
Thank you so much, Tan Sri Sharif Qasim and distinguished panelists and participants. Assalamu alaikum, ni hao, wanakam, nunu habar, sat sri akal, and apa khabar. I'm honored to be part of this panel, and I plan to speak with you about reform of Parliament. Huda, could you give me the slides? Yes, next one. In almost all of the 33 or so Westminster type of parliamentary governments, a wide gap exists between the theory of responsible government and the reality of an omnipotent executive. The effort to bridge this chasm is a continuing challenge around the world, including in countries like the UK, where as early as 1929, Lord Hewitt had written a book called The New Despotism. Next slide. The concern over the decline of Parliament is neither new nor confined to Malaysia. The factors that have contributed to this decline are many, and I won't be able to cover them. Let me instead hitch myself to the aspirations of our Constitution. What does the Constitution envisage for Parliament? And let's look at the constitutional scheme of things. Next slide. The role and function of Parliament under the Federal Constitution. In our Westminster style of parliamentary government, the legislature is supposed to perform a number of functions. Number one, the legislative function. Now, here is my view of it. This includes the enactment, amendment, and repeal of ordinary laws, emergency laws, special amendments to the Constitution. And ideally, the legislative role should also include the scrutiny of subsidiary legislation, in England called delegated legislation, and a leadership role in law reform. Number two, oversight of executive policy and performance. This is well illustrated in Article 43, Clause 4. The Cabinet shall be collectively responsible to Parliament. Next slide. Control of national finance. This covers several aspects. Oversight of the government's long and short-term financial and economic policies. Examination of the use of financial resources optimally. Allocation of the annual budget and supplementary budgets. And number four, the Dewan Raj Public Accounts Committee to review the Auditor General's annual admonitions of the use and misuse of allocated funds. Next one, number four, the constituency function. MPs are supposed to represent the Rayat and to obtain feedback on government's policies and programs. Number five, the giving of democratic legitimacy to the government in Parliament. Under Article 43, Clause 2A, the monarch should appoint a person to be the PM who, in his royal judgment, is likely to command the confidence of the majority of the members of the Dewan Rayat. Next slide. Function number 6, giving representation to the electoral constituencies after a general election. Each MP, each of the 222 MPs represents a particular constituency. Number 7, functions during an emergency. This is very relevant to what's happening today. During an emergency, Parliament is not automatically dissolved or suspended, though it may be. In 1969, there was no Parliament for 24 months. This time, there has been no Parliament for 7+ months. Actually, Article 150 on emergency gives to Parliament three major powers and functions during an emergency. Number one, to scrutinize the Yang di Pertuan Agong's emergency proclamation, and if need be, to annul it. Number two, to scrutinize the Yang di Pertuan Agong's emergency ordinances, and if need be, to annul them. And number three, to enact emergency laws under Articles 150, Clause 5, Clause 6, and Clause 6A. It is wrongly believed that during an emergency, only the Agong can make ordinances. That's not correct. Agong can make ordinances only if the two houses are not in session concurrently. Otherwise, the power to make law remains with Parliament. Please don't forget that Malaysia was under an emergency from 1964 till 2011 November. During this time, 10 general elections were held. Parliament sat, passed hundreds of laws, made scores of constitutional amendments. So Parliament is not marginalized under the Constitution. Next slide. Number 8, to have the last say on the electoral boundaries done every 10 years by the Election Commission. Number 9, safeguarding Malay Reserve lands. If in a state a Malay Reserve is degazetted, the matter must come to the Federal Parliament and a vote of an absolute majority is needed. Number 10, to exercise parliamentary privileges. And may I point out, parliamentary privileges are not only meant to protect MPs from civil and criminal action. It is an exercise of parliamentary privilege to discipline any MP who misuses his privilege of freedom of speech under Article 63. Sadly, Parliament doesn't perform this role very well. Number 11, last one, the Dewan Negara has the additional function of representing the 13 states. So each state sends 2 indirectly elected senators. And of course, the federal territories have 2 senators. So 3 senators. So this is the Dewan Negara gives voice to minorities and marginalized groups in the sense that 26 senators represent the states and there are 44 appointed senators by the Yang di Pertuan Agong. They are supposed to represent marginalized groups and minorities. I emphasize the word supposed to. That was the intention of the Constitution. It hasn't worked that way. Next slide. Now, I'm afraid I don't have the time to cover all these 11 functions. I'll just concentrate on one, and that is lawmaking. Next slide. The making of laws. The political executive dominates the legislative agenda. It drafts the bills. It determines the timing of legislation. It uses its whips to push through legislative proposals without much scrutiny, even if animated debate takes place, and sometimes it does. Ultimately, MPs have their say. The government has its way. Private MPs are not allowed much role. In 64 years, there is no record of a successful private MP's bill having passed Parliament. Many were introduced, but they were not passed. The tradition of select committees to scrutinize bills has not taken hold. Actually, under the standing orders, every bill can be committed to a select legislation committee. I'm sorry to report to you, in 64 years, only 10 to 15 times bills have been committed to select legislation committees. Then the Dewan Rakyat generally passes a bill without substantial amendments. I once did a personal study over the period of 3 years. I found that 80% of the bills were passed without a comma or full stop being altered. So Parliament basically legitimates. It does not legislate. Next slide. Under Article 68, the Dewan Negara is subordinate to the Dewan Rakyat. Even if the Dewan Negara refuses to pass a bill originating from the Dewan Rakyat, The Dewan Rahat can bypass the Dewan Nagara after prescribed time limits, 1 month for money bills and 1 year for non-money bills. The Dewan Nagara asserted itself in 2019 for the first time in Malaysian history by defeating the Fake News Act. So that's the only time the Dewan Nagara ever said no to a Dewan Rahat bill. Next slide. Before bills are laid down for their first reading, they are embargoed under the Official Secrets Act. Even after the bill has been laid down for the first reading, there is no widespread tradition of engaging relevant stakeholders to discuss the bill, even though standing orders of the houses permit the establishment of legislation committees. So public participation is not only minimized, it is obstructed because the bill is sulit and tarhat. Next slide. There is no joint parliamentary committee to scrutinize the mass of subsidiary legislation. May I point out to you, for every one act of parliament that parliament passes, there are nearly 15 to 20 pieces of subsidiary legislation under that act of parliament. So actually, executive makes 20 times more laws than parliament, and yet parliament plays no role in scrutinizing subsidiary legislation as is common in other countries. Then parliament plays no role in law reform. Bills passed by parliament generally contain a clause. This is shocking, really shocking. They generally contain a clause authorizing the executive to determine the date of enforcement. The executive often delays the gazetting and the enforcement. Example is the constitutional amendment passed in 2019 to lower the voting age from 21 to 18 was passed in 2019. It has not yet been enforced. Why? Because the bill says, the amendment bill says that the following clauses shall come into effect on a date to be determined by the Yang di Pertonagong, who of course acts on the advice of the government of the day. So it is quite clear the center of gravity of the lawmaking process has unconstitutionally shifted from the legislative branch to the executive branch. In the area of lawmaking, the executive is more important than parliament, even though parliament was elected at great expense. The last election cost 500 million. I'm told the next election may cost up to 1 billion because of the COVID-19 crisis. Next slide. So what reforms can we propose? First of all, policy papers to enable MPs to be better informed and to enable citizens and affected interests to work with MPs. The government must issue policy papers on what the bill is all about and publicize it, print it in the newspapers. Why should this be so? Because decisions in which people participate are decisions they are likely to respect. Next slide. Lifting the secrecy surrounding bills. Bills should not be subject to Official Secrets Act till they are laid in Parliament. We must give MPs more time to read bills. Sometimes the practice is just the day before. It should be submitted to them at least a few weeks in advance. There should be select legislation committees. Next slide. Private MPs should be encouraged. Actually, the standing orders allow for that because this will enhance the role of backbenchers. By backbenchers, I mean those who are not in the cabinet. Such bills may involve participation by NGOs and reflect the democratic impulses of society. Such a bill may enable the government to avoid paying a political price if the bill, though badly needed, is opposed by public opinion. Now, this is something I wish to emphasize. Often something is badly needed, but it is politically dangerous, so the government does dare not introduce it. A good technique would be allow a private MP to introduce it, take the blame or the credit for it, and then give to the MPs freedom to vote as they like. May I give you an example? In the UK in 1957 or 58, the government wanted to decriminalize homosexuality. But that would have been controversial from the moral point of view. So the matter was left to a private MP to introduce the bill. And the government let MPs have freedom of conscience to vote as they liked in favor or against the bill. In my view, private MPs should be encouraged. The Speaker's office should draw lots, and those whose names appear on the top 4 slots should be given not only guaranteed time, but financial aid to submit their proposals. Next slide. Increasing the number of sittings. The Dewan Rayat meets about 70 to 80 days a year. The UK practice is about 170 to 180 days a year. In 2020, the Dewan Rayat sat for only 55 days. And this year, due to the emergency, the first meeting was on July 26. The Dewan Nagara's record of meetings is even more embarrassing. It sits 15 to 20 days in 1 year. Part of the problem lies in Article 55, Clause 1. It allows 6 months to elapse between the last sitting in one session and the date appointed for its first meeting in the next session. Now, increasing the number of sittings will assist Parliament to perform its roles more thoroughly. Next slide. Legislative assistants, MPs, even in some Asian societies, not so well off economically than in compared to us, MPs must be provided 3 to 4 legislative assistants. I know this will cost money, but MPs must have research staff to assist them to perform their parliamentary work. Next slide. Reform of the Dewan Nagara to lighten the legislative load of the Dewan Rayat and to enable greater scrutiny of legislative proposals. Some politically non-controversial, non-money bills could originate in the Dewan Nagara. This will require both houses to sit together. There is nothing in the law to prevent that from happening. It's purely an administrative measure. The Dewan Rayat always sits first, then the Dewan Nagara comes on. They should sit together. Next slide. Thank you. We should activate Articles 45, Clause 4A and B of the Federal Constitution to bring about the following reforms. Number 1, enable Parliament by law to increase the number of senators elected in each state from 2 to 3. Number 2, to provide for direct election of the state senators by the electors in that state. Right now, the state assembly elects the senators, the 2 senators. Number 3, to reduce the number of appointed senators to no more than 1/3 of the elected, indirectly elected senators. Today, it's the other way around. Today, actually, there are 26 elected senators, indirectly elected, 44 appointed senators. 2/3 are appointed, 1/3 is elected. It should be the other way around. Next slide. Convention should be developed to allow professional bodies, trade associations, minority groups, and cultural bodies to nominate persons to be appointed as senators. The Constitution should be amended to allow MBs and CMs to participate in Dewan Nagara deliberations on issues of state rights under the federal system. Next slide. Emergency. Prior to 1981, it was the law in Article 150, Clause 2, that if a proclamation is issued when Parliament is not sitting, the King shall summon Parliament as soon as may be. This clause was repealed in 1981. I think we should restore this clause. Next slide. The emergency proclamation and ordinances are required to be laid and debated and discussed if a motion is introduced. However, since the 1960 amendment to Article 150, Clause 2, which I mentioned to you, there is no requirement anymore that the proclamation and the ordinances be affirmed. They need to be laid, but if Parliament does nothing, then silence is deemed consent. Next slide. Constitutional amendments. Laws cannot stand still. For this reason, The Perlembagan permits Parliament to amend the Constitution by following the prescribed and difficult procedures of Articles 1 Clause 2, 159 Clause 3, 159 Clause 5, 161E. Article 1 Clause 2 says that if you want to amend the territories of a state, like take federal territory away from Selangor, then you have to get the consent of the Selangor Assembly. 159 Clause 3 requires 2/3 majority. 159 Clause 5 requires consent of Majlis Raja Raja. 161E requires consent of the Yang di Pertuan Negeri. Now, however, there is an ongoing and unresolved debate about whether Parliament can, by following the prescribed procedures, amend the basic structure of the Constitution. Our judges are deeply divided on this issue. Another controversial issue relating to some amendments is that some constitutional amendments require the consent of persons or authorities outside of Parliament. As I mentioned, in some cases, the State Assembly is involved, Conference of Rulers is involved, and the governors are involved. However, whether this consent was in fact received or not received is never indicated in the Gazette notification which publishes the amendment. It is my humble submission that in the matter of constitutional amendments, the Government Gazette must inform the public whether and when the consent of the Conference of Rulers and the governors or the State Assembly was obtained. Next one. Law reform. I have a humble suggestion that every piece of law passed by Parliament must contain a provision to require the minister concerned to appoint a post-legislation citizens oversight committee working pro bono. So no money is involved. Pro bono is free, to keep the working of the law under scrutiny. The committee should have at least one legal member and 2 other persons to represent affected interests. The committee should be required to report to the minister every 2 years or earlier if necessary. And then once the committee has reported to the minister then should, by way of delegated legislation, make the necessary reform, or if the reform is a major one, report to Parliament that its act needs to be amended. Next slide. There should be a law reform commission, independent law reform commission of retired judges, academicians, lawyers, and I will go along with Dato' Hishamuddin, at least one non-law person, because laws apply to everyone. I think such a commission should exist. It should keep all laws under review and report to a joint select committee of Parliament on law reform. At the moment, there is a law reform committee in the Pejabat Peguam Negara, but I have to say this, in my view, it's not independent. It suffers from conflict of interest. First of all, they draft the law. Now they are supposed to reform it. I think there is a little bit of conflict of interest. Next slide. Subsidiary legislation, as I mentioned earlier, should be subject to a joint committee of the 2 houses for review. At the moment, subsidiary legislation can only be challenged in a court of law, but that's very expensive and time consuming. Next slide. Next one. That's all. Thank you, Tan Sri. I will skip these financial implications. My main point is this: most of the amendments I recommended require no amendment to the law. They can be done administratively, but there will be some need for new laws, for example, for a new law reform commission like the Judicial Appointments Commission, but this can be done. Thank you very much, and thank you, Huda, for your expert handling of the slides. Thank you. Tan Sri, Tan Sri Sharif is on silent. Unmute. Yes, now
Hello.
we can hear you. Yes, yes,
Ah,
sir.
yeah, thank you very much, Professor Shad Salim Farooqi.
Thank
Now
you.
we go to the last speaker, Tricia Yu. Tricia, can we welcome you? Tricia?
Hello, good afternoon, everyone. Thank you so much to G25 and EdUnity Foundation for inviting me. I am very honored to speak alongside so many esteemed and distinguished speakers. Tan Sri Sharif, of course, thank you for the invitation. Tan Sri Rebecca, our IDEAS board member and friend, Professor Shad Salim Farooqi, and Datuk Sri Hishamuddin Yunus. So good afternoon to everyone also in the audience who might be listening in. I think we are actually quite late in the day, so I hope not to belabor you too much. But I just wanted to point out that all of the above institutional reforms that the speakers have talked about are absolutely crucial. Many of them have been addressed in the IRC Institutional Reform Committee. Unfortunately, that report was not out. It was not declassified and made transparently known to all of the public. So I urge that this report be made known, because then we don't want to reinvent the wheel and to recycle the proposal reforms. There are two specific things that IDEAS has had an interest in the past. So we've published a paper on the separation of powers between the Attorney General and Public Prosecutor. So that's on our website. And the other one is on Senate reform. So we've also published something on reforming the Senate. I take Prof. Shad's points, all of them are very relevant. And IDEAS, in fact, is part of a separate civil society coalition called the Seed Community for a Professional Parliament. We've also met with Prof. Shad recently, where we're trying to use several projects that will professionalize Parliament, and completely agree there's a need to increase the number of select committees, making sure that Parliament is strengthened and not just the executive, because what we have today is a highly centralized government in which the executive makes those proposals and legislature does not have very much say except to debate, but the debates are also very limited because we don't have many sitting days. But right now, I'm going to talk about another area of institutional reform, which is to address political corruption through political financing reforms. So just to talk through what is Malaysia's current situation. Malaysia does not currently have any legislation to regulate the funding of politicians or political parties. Therefore, this means there is no transparency in how politicians and political parties raise money. There's no public funding for political parties, unlike countries like Germany. So Germany is the country that is often cited. And the boundaries between party spending and development spending are not clear. So the government does provide some development spending to its members of parliament. But even then, it is not equally divided, and there's a lot of controversy there. But before we get into the details, so I just want to broaden out a little bit. So there are a lot of institutions like the OECD and others that are already starting to think about money in politics as a crucial piece of the jigsaw to improve political competition and trust in government. So this report is available online. It essentially says that money is a channel of political participation. So we just want to acknowledge that. Money reflects and shapes political competition, and money influences politics. And of course, we know, especially so in a country like Malaysia, politics influences policy. So what we're saying is that money therefore matters. Money influences politics. Money influences how policies are shaped, are formed, and how they are implemented, which therefore have an impact on the rakyat. This is a very renowned organization called IDEA. They do a lot of research on democracy and electoral assistance. And this is an interesting report because I know that today's topic is specifically tied to the COVID-19 pandemic and looking beyond the pandemic. And so it's interesting that even these organizations are examining how COVID-19 will have a unique and unprecedented impact on the flow of money in politics. In countries, especially where there is public funding, this will depend on how governments can actually afford to fund those parties, or will they redirect their money into sustaining more economic recovery issues? We know that in Malaysia, I'm sure if any of you have been to these like political charamas, they will hand out a little box that you can put money in. But restrictions on the size of gatherings will also make it difficult to organize fundraising events. So I think the interesting question for us when we think about institutional reform is how can reforming political financing actually strengthen our institutions? The two immediate things that come to mind would be, number one, by doing so, we would achieve stable political parties. Number two, this also establishes transparency and accountability, which in turn establishes trust and goodwill in a certain government. I do believe that at this moment, there is a trust deficit in politics generally, but also in the system of government. So we really rapidly need to think about how we can strengthen our institutions through the reforming of political financing. Okay, so essentially what is at the core of the argument? The core of the argument is that Malaysia needs a political financing act that contains the following provisions. Declare donations above a certain amount. Number two, prohibition of foreign funding. Number three, a prohibition on GLCs, because this happens. Number four, a public funding mechanism. I'll speak a little bit more about public funding. Number five, a reasonable limit on donations as well as a reasonable ceiling on expenditures. So again, maybe drawing onto the bigger picture, what are the principles of political financing? And we also have a publication on our website on this. So the principles, generally speaking, I think we want to agree that there has to be a rule of law, meaning that all parties are treated equally. What happens today is that these things called the constituency development funds, so that's the only form of public funding that are given to elected representatives. The parties are not treated equally in that way. However, I must congratulate the current administration for providing the food baskets in equal amounts to both government and opposition MPs. So that is unprecedented, and I do hope that this sort of equal or equitable CDF distribution will continue. Number two, fairness for all involved, namely voters and political parties. Number three, transparency, accountability, and ownership by the electorate. Number four, checks and balances to prevent unlimited power. And number five, the exercise of political and civil liberties by the electorate. We know that enacting legislation is not the goal, but it's only a step along the way. So we have to ensure that there is good enforcement. There has to be also meaningful, bold changes in the political culture and norms, political literacy among citizens. State welfare institutions also need to function efficiently, and the change needs to happen from within the political parties themselves. Okay, before I get to the details, so the next few slides actually are detailed tables of the various proposals that have been put forth prior to this. So maybe just a little bit of background and where are we at in terms of the discussion on political financing. So political financing is not a new subject of discussion. It has been taking place over the last decade. So over the last 10 years, a lot of groups have taken a lot of interest in it. I think it also escalated precisely because of the 1MDB case, which, as we all recall, blew up in 2016, 2017, and this resulted in, well, partially resulted in the change of government in 2018. So back in 2011 already, Transparency International was the first organization amongst the civil society here to emerge with a very comprehensive report with 23 recommendations. So there's a little red book, if any of you remember, very comprehensive. Following that, there was a bit of a silence because when they proposed these to the different parties, from what I understand, the traction was not quite there. In 2015, 2016, two parallel activities took place that also emerged in a report, two separate reports. Number one, there was a civil society coalition, which was led by none other than G25 at that time. G25, C4, a couple of others, they came together and formulated a report. Separately, the government under Datuk Sri Najib at the time also commissioned a report via their own committee. So there were two parallel reports around the same time, 2016. From then on, there has not been any new report. However, what the Pakatan Harapan administration did was that they also called for the formation of the Institutional Reform Committee, which has been talked about several times here. And there was a report that came out, but the report has not been made public. And within that report, there were proposals to have a political financing legislation. And there is actually a draft of this legislation. And the legislation draft is sitting at the Attorney General's chambers. And no one has had access to read what the draft says. So the point is that since 2018 or maybe 2019, there has been no progress with regards to the Political Funding Act. So now I will go through some of the details of what it is that many different groups as well as ideas is trying to propose. I will end by sharing with you what ideas itself is doing on this front. And then I think I'll just conclude because it's rather late. So some of the main principles, right? Transparency and disclosure. I think no one can argue that this is the primary principle. And what I did is also to analyze what do the three different reports say with regards to transparency and disclosure, because there are many different principles and there are some disagreements as well among the groups and the parties. So firstly, TI's report says mandatory disclosure of all financing and expenditure. The NGO coalition talks about disclosure of more than 50 ringgit in a single or multiple donation. I personally think that's a little bit low. The National Consultative Committee talked about full disclosure of all political income and expenditure of political parties and politicians. And the next slide talks about independent entity. So some of them say that there does not need to be a separate independent entity, except for the National Consultative Committee, which said that there should be an independent controller. I want to highlight that their report also called for a parliamentary standing committee on political financing to scrutinize the work of the controller on behalf of Parliament. I will come back to this parliamentary standing committee because it's relevant to some of the things that we are doing at Ideas. Ban on GLCs. This seems to be common across the board. All reports said that GLCs should not be allowed. Having said that, I want to also highlight that C4 has done a very good report recently that talks about how parties actually bypass GLCs, but they depend then on foundations. So if you see a lot of these yayasans everywhere, yayasans have become, and these different foundations have become the new source of political funding. So GLCs, because there is government presence and some scrutiny, they are not being used as much anymore. Are there limits on donation and expenditure? TI and the NGO coalition say yes, there should be limits, but the National Consultative Council Committee said no, not to have limits. Okay, and then this one is very interesting. So I mentioned that I would come back to public funding. Where we're at this stage in Malaysia, I do believe that there needs to be some form of public or state funding involved. And I say this because I've been speaking a lot to the different political parties and representatives from the parties. And I believe that in order to convince and persuade every party to take up the cause of transparency and disclosure, tying it to some form of public or state funding is a good idea, meaning that because the parties are going to receive some form of state funding, this is where the accountability comes in as well. So TI talked about two different types of funding. One was electoral competition funding. The other is a monthly allocation for elected representatives. The NGO coalition in 2015 talked about public funding as well. The National Consultative Committee also talked about state funding, so yes. And another one I want to cite recently, which is Bersay's report on public funding. Also, they recommend that there would be vote-based direct funding for regular party and campaign expenses. So it seems that based on these various reports and these various opinions, there is a case to be made for public funding. Okay, let me just stop sharing and then I will conclude my thoughts on this. So in terms of political funding, it seems quite straightforward to me that transparency and disclosure as a main principle that should remain the order of the day. In order to obtain that transparency and disclosure, one should consider the possibility of public funding because this is where you can tie the accountability very closely to taxpayers' funds. Where we're at ideas, if I can share a little bit, is that we are trying to work together with civil society organizations as well as members of political parties to form some sort of parliamentary grouping that will allow us the opportunity of calling for the draft bill that no one has quite seen yet. We believe that this is an opportunity for Parliament to play its role, as Prof. Shah so succinctly put earlier. And Parliament should be able to scrutinize the draft bill, call on perhaps experts, international experts, regional experts, countries that have already implemented some sort of political financing act, and maybe troubleshoot what are the gaps that need to be made. And hopefully with this sort of coalition building, this will also translate finally into the legislation coming into place. So just wanted to keep it short. I think that's quite clear. In some, I believe political financing reforms are also a very clear way of ensuring institutional reforms are obtained. It's part and parcel of what we need to do. Ultimately, a lot of things we can try to push forward, but unless we address the problem of political corruption in the country, I do believe that this is, in a sense, the mother of, not maybe all problems, but the mother of many, many problems. Unless you weed out political corruption, unfortunately, all of the above institutional reforms that we are hoping to achieve will also be very, very difficult to obtain. Thank you very much to G25 once again, and happy to receive questions.
We have about 20 questions from listeners. 3 are about the civil service, the first topic, and the rest are all about parliament and judicial reforms and political financing. One common question is there a political will to carry out these reforms? I think it's based on what we hear from Tricia, for example. There was a serious attempt made to introduce a law on political financing. And it all started, with a statement by Najib himself. As you may recall, when it was revealed that, he had $668 million US in his private account, and he was criticized. And he told the public, he said to the public, I've done nothing wrong. It's not against the law. This is a donation I received from outside. And according to the experts like Professor Terence Gomez, Najib was right. There's nothing in our law which prevents foreign political financing. And so Najib said, if you think it is wrong, let's have a law, let's legislate it. And so he appointed a committee under Paul Lau, and Paul Lau tried to do something, but unfortunately, the bill got nowhere. So there was an attempt made, but actually it was a stalemate. But now As Tricia was saying, there's a new move now to form an all-party parliamentary group to get this, because there are more and more members of parliament who are beginning to feel that we need such a law. But the question is whether the majority will agree. So this is, we have to see. And again, on parliament, I would say in the previous administration, the Speaker, Tan Sri Arif, he pushed hard for reforms. He formed the parliamentary select committees. But of course, he said parliamentary select committees can only be effective if you provide it with the necessary support, staff support, budgetary support. He wanted all those reforms, but those reforms, I think, the Pakatan Harapan government fell, and those administrative changes that he wanted, didn't have time to be implemented. So hopefully there will come a time when a new government perhaps will take it up again. And another interesting comment, as I said earlier, was from the Minister of Law himself, where he said that the government is prepared to consider the proposal to separate the functions of the AG. As you know, these reforms proposals have come from many civil society organizations. And hopefully, working as a group, we cooperate among each other, we can see some progress. But in the end, it's a question of who we put into parliament. And in the end, it's left to the hands of the electorate. If they are reform-minded, if the young people come forward to vote, you bring in a new set of parliamentarians, maybe the reform process can happen faster. Because there are many of the questions that I receive here, they look like they are skeptical whether we can achieve anything. They say, if there's no political will, what can be done? True, but on the other hand, as I'm trying to point out, there are areas where there was progress being made, but unfortunately, because of the political changes, everything came to a stop. I think we shouldn't stop, we should revive. And that's one of the reasons why, despite the pandemic, we decided that G25 should have this webinar, should keep these topics alive in the public mind so that they don't forget, so that we also don't forget. And I think if we work together across civil society groups, we can.
Yeah, Tan Sri, if I may as well interject. So the question always comes about, right, these kinds of forums, like, is there political will? And it's only if the political will is there, so on and so forth. Politicians, they are human beings, right? Just like us. What are we incentivized by, and what are they incentivized by? I think we, as an organization, as a think tank that does this sort of policy research and advocacy, we come to that stage where we appreciate that there are some things that politicians won't move on, but there are many things that they will move on if we are able to demonstrate that there are incentives for them to do it, and there can be successes that can be demonstrated, right? So it's not just I think we also don't want to see government as like a monolithic entity. There are so many different players. There's different ministries. There are different players within the ministries. We talk to the various people within the ministries. There are agencies. There are civil servants. And so some are more motivated than others to make that change happen. But we need to find what are the levers that ensure these things move along. Like, what are the levers of momentum? And I think it's very clear that in some instances, when the government feels it is to their advantage to do something and the pressure mounts very high, that they can actually move the needle. So this happened when, say talking about Bersih, which is a long time ago now, but without Bersih, there would not have been a parliamentary standing committee to reform some of the election laws, and very importantly, to make overseas voting possible. I think we forget some of these things that have happened along the way. Remember that overseas voting did not happen in the past. It's because of some of these pressure points that were put. And this committee that I talked about on political financing, I don't think that Najib would have formed that committee on political financing if there had not been all of this pressure. If you recall, The Edge was doing this coverage. Yes, they got their license suspended for 2 months. But there are moments which there's like a kind of a perfect storm where different points come together. And I would say that, yes, government and politicians, they are listening because ultimately what they care about is the reputation. So I would say let's not lose heart because these are all the roles that we play in different ways. And it's not like, there is no monolithic government and there are variations there as well. Thank you.
Okay, let me now, to be fair to our listeners who have raised questions, let me quickly read through some of the questions. Now, first on the civil service. Current members of the civil service might disagree with the reforms as they are uncomfortable, as they are comfortable. How do we get around to those already set in their ways? Second question, what is preventing reforms in the civil service, especially with regard to inclusivity, diversity, and meritocracy? Inclusivity, diversity, and meritocracy. And the third question on civil service, politicians rely on the civil service to govern the country. The civil service in turn relies on government for good pay and conditions. What is the motive for reform? Can you quickly answer those questions?
Very quickly, Tan Sri, thank you very much. I know those questions, those are very difficult questions, but they are very relevant questions. At the end of the day, it is up to us to keep this conversation going. It's not going to happen overnight. So I agree with Tan Sri Sharif that it's important that we have sessions like this and keep the conversation going and engaging the right people. I remember when I first was asked to take part in this webinar, I asked Tan Sri Sharif, will I be preaching to the converted? It is important to get the key decision makers, i.e. KSN, the Chief Secretary of the Government, the head of civil service, KPPA, and the KSUs. We need to engage them. And I think sometimes the public forum is not ideal. It's a private conversations, smaller group conversations, so that folks appreciate what is being done. This, and you need a champion, really. So at the end of the day, I must say, I came through the system, and you need sponsors, you need champions who believe in you and allow you to grow. You need leaders who will have that mindset of, I don't know everything. I don't have all the answers. I am going to tap into the strength of the people around me. That's the kind of mindsets you need. But really, at the end of the day, it's having those smaller, intimate, deep conversations about why the civil service, we understand it, but the essence of it, what's in it for you all if you do these reforms? I think that's the kind of conversation we need to have.
Thank you. Now I go to the next one. How to stem bribery and corruption in the judicial system, etc., like in the case of AKER Solutions. I don't know what AKER Solutions is. AKER, A-K-E-R Solutions.
AKER. That's
good if we have a CJ who chose to report on the matter. Number two, a report on this has been submitted to the PH government. Would think the issues are the same regardless. Can this be used as a good guideline on this topic? I think this is a general question. Next one is about culture, but we tend to respect more on age and seniority, not on not on meritocracy. Next one is issue of contract doctors. Is it right time for government to promote privatization of civil service? I don't know what that means. This is about judicial system. Why is no one looking into improving our judicial system to make it sure it is strictly independent? It seems untouchable. What can we laymen do to help? The next one is about health personnel. Next one, then this is directly to Datuk Sri Syam. Hi, Datuk Sri Syam. Just want to ask, since you pointed out about amending our federal constitution for judicial reform, how can we ensure there is political will in that? Yeah, I think generally on the political will, both Tricia and Rebecca have touched on that. I agree with what they said. Next one, problems in this country is MPs easily jump and join other party to form a government. To what extent will the anti-hopping law be able to solve this problem? This hopping of political parties has a lot to do with political financing too. They go where the money is. So I think if we do something on political funding, perhaps we can also deal with the problem of anti-hopping law. Next, the flaw in our current policy is no clear separation between legislative and executive MPs and executive. MPs are also executive. This is a point stressed by Professor Shad, but this listener, Mizi, her name, I think, he or she, she's, I think it is she, I think she says the US system may suit us better. Oh, comment, please. I think we're talking about a total change of the constitution that might be too ambitious. What is the status of our parliamentary select committees? Is the government slowing down progress on this, and why are they doing so in your opinion? Our parliament just reopened. The fact that there was such resistance to it reopening is a worry. What can be done to avoid similar resistance in the future? How can parliament be reformed to ensure it can still function despite emergencies? Or would there be a separate bipartisan advisory body? There was a lot of then political financing. We have covered that. Next question, what can us laymen do to help you all with pushing all this reform? Thank you. Tan Sri Rebecca, you are a rarity in the civil service at your ethnicity. Oh, how can we have more non-Malays in the civil service if this is needed? Is this needed? Can we get the media to be a bigger player in pushing for these reforms? I think the media has, we never mentioned about the media so far, but I think when I look at the situation in UK, in US, really, it's not just a politician, it's a media who really come out and really bring up the issues into the open. I come to the media too because of the laws in this country, restrict freedom of expression, but the media is really not playing its role. Anyway, I open it to the members, to the panel members. Anyone, any one of you can just jump in. Datuk Sri Syam, you want to touch on the...
Okay, Tan Sri, thank you. I can detect there two questions, meant for me. The one is the Eco Solutions case. That one I can give a very brief answer. Have you been following that case, Tan Sri?
Yeah.
Have you been following that case?
No, I'm afraid.
It was high news, I think, quite about 3 weeks, a month ago. But now everything is quiet. Is involved, I think, a foreign company, is it Norwegian or Danish, big shipping companies. So there's allegations, allegations of corruption, but it's a mere allegations. Hmm? Um, and a WhatsApp, inappropriate WhatsApp conversations. So I can't say much at the moment because, well, the first principle is that, a person, okay, this other mentioned about the corruption, but the principle is, a person is presumed innocent until proven guilty. That is like a cardinal principle of justice. So I can't, so we have to presume that everyone there at the moment are presumed innocent until proven justice. So in that case, as a matter of fact, all the parties have respectively lodged a police report, disassociating themselves with that inappropriate conversation in that WhatsApp. And it is in the process of police investigation. Because it's in the process of police investigation, I don't think I can say more than this. So I will end there itself. Let the police investigate and come out what do they find from their investigation. Number two, political will about reforms. Well, reform, who's in charge of the judiciary when it comes to reform? The judiciary administratively comes under the minister in the Prime Minister's Department responsible for the judiciary. And we call it the Minister of Law. So he's the one, that has to ensure not just the administrative part, staffing and all that, salary of judges, but also the judiciary is in the right track, and should look forward to enhancing judicial independence. Now, but more directly, how do we ensure? I think back to the question of political will. There must be a government that has the political will that believes in an independent judiciary. So we must have a government. So we, as members of the public, we have to usher in a government that believes in that value, that values independent judiciary. So it all depends on the government then. So it's up to us. It's up to us. We have to look around. Which members of parliament, which parties do believe in such values? So if we can identify a member of parliament or political parties or government that values judicial independence, then go for it. Go for it. Usher that political party into the government, and hey presto, hopefully we get what we want. At the same time, and on the side, civil societies also must play their part. Civil society, and I know there are many civil societies, and I think ideas, and also G25. I can't say G25 because I'm a member, and conflict of interest. But I think G25 also believes in in institutional reform, including reforms of the judiciary, reforms of the Attorney General's office. So members of the public must give support. In these civil societies that believes in institutional reforms. Thank you, Tan Sri.
Thank you. That's a very good.
Yeah, can I just jump in? I agree with Dr. Sri. We all have a role. This is not just an individual. It's all of us together. And I'm an idealist. I've always been an idealist. And I think we can, if we band together, civil society, the media, we can institute some change. We can make changes happen. Trisha,
Yeah.
we are the few that are, that's my concern. As I keep saying, I don't want to be preaching to the converted, but we need to engage those who have the leverage, those who can, move the needle. We need to engage them.
And all we need to do is look at Indonesia. Indonesia is what at one time was a very repressive country, very, very corrupt. Everything was bribery. But they have come a long way. They have made a
Yeah,
lot of
but
reforms.
I think we also need to speak up.
Can
Tanvi.
also
We
be.
need to speak up. For example, the issue of the contract doctors, the issue of folks who are being, we don't want to appear, we don't want our people to be subjected to high-handed authoritarian, actions, and those are things we must call out. We must try and speak up, whether it's the doctors, whether it's NGO members who are being called up under different laws in the country. We need to be able to speak up.
I wonder whether Professor Shad is still with us in the panel.
Yes, I'm still with you, sir. I'm still with you,
want
Tansri.
do you want to say? We have about 1 or 2 minutes left. If you can be quick to summarize
Yeah, yeah, Tansri, there were several questions addressed to me. I'll try to be brief. First of all, was a question on party hopping. And of course, as you said, it's connected with the political donations and bribery. The problem is this, that we have number of cases. The most famous is Nordin Saleh. The Nordin Saleh decision says that associating, reassociating is part of freedom of association under Article 10, Clause 1, Subclause C. So a person has a right to join a party and leave a party and join something else. So there is this issue. However, I disagree with the Nordin Saleh decision on one ground, and that is this, that the right to association is subject to 3 restrictions. One of them is morality. Now, to me, morality includes political morality, not just conventional or sex morality. But the learned judges in the case said morality basically means conventional morality. So I think the right to association need not stand in the way of MPs being required to recontest if they change parties. I'm not saying that they should not be allowed to change. If they genuinely want to change, I think that should be their right. But they should go back to the Rayat which elected them and say, I have changed my value system, or I have changed my ideology, re-elect me. So I think it can be done. Many countries have done it. India has a very significant anti-defection laws. Many other countries do, which now raises the issue of the next question: should we adopt the US system? Defections have one great evil surrounding them, and that is this: they may cause the fall of a government. See what happened actually here in this country last year in February, was it? 2020. What happened in Perak, the Zambri, and the situation. So defections can cause the fall of a government. In the US, defections have no effect because the president is elected by the people for a fixed term. If you don't like him, that's your problem. He is there for a fixed term. He cannot be removed by the Congress except on a process of impeachment plus conviction. And no president has ever been removed by impeachment and conviction. Several were impeached. That's half the process. But the conviction did not take place. So should we change to the US system? Well, this is a drastic change. The main advantage of the US system is that the president has stability. Secondly, he is there only for 8 years maximum, 4 times 2. He can't be prime minister for 30 years or 22 years. That itself is bad because then power gets personalized. However, the disadvantage of the American system is that the president can be Republican, Congress can be Democratic, or vice versa, and they are constantly at loggerheads with each other about laws. Sometimes budgets are not passed. Whereas in our system, the PM can pass legislation. So the pros and cons are very significant. I think we need a separate seminar on this issue of Westminster system versus the Washington system. And finally, Tansri, this emergency because of emergency, there is reluctance to bring parliament. I don't think so that emergency stands in the way of parliament. As I mentioned to you, under Article 150, Parliament has three important functions, including the making of law. And may I again reiterate, we were under emergency from 1957 to 60, from 64 to 2011, and Parliament met. Elections were held 10 times. So emergency doesn't stand in the way. Emergency, what it does is, it makes Parliament more powerful. The limitations that the Constitution imposes are removed. And if Parliament is not in session concurrently, then the Yang di Pertonagong acquires a parallel power. Thank you.
Thank you very much. I'm afraid that's all the time that we have. As usual, this is a very big, very, very big topic. One topic itself can take 2 hours to discuss. So we have we put 3 topics. We had 3 topics in the discussion. But anyway, I think our listeners, I'm sure, will have gained something that. I just want to end by saying that all is not lost. I think as long as civil society keeps on the pressure.
Yes.
And I think if the public, also becomes more interested on the issues of reforms, and if the media can put up more courageous attitude to publish ideas about reforms, then I think we will see progress. And as I said before, sometimes crisis did bring about progress. I think Tricia, you mentioned how all nations got together, even from London. They came around rushing to bring the votes from London, which resulted in a change of government. And so the May 2018 election shows us that if the public is sufficiently aroused, they will act.
In my lifetime, I have seen several movements come up along with Bersih. For example, in the 70s, consumerism was a dirty word. Being a consumerist meant that you are anti-development. Women's rights were actually, you are too liberal, you are anti-religious. In the 70s, if you were an Islamic advocate of Islamic State, you were being watched by the special branch. But then in the 80s, the thing changed. So what I wish to reiterate what you were saying is that actually, if we are persistent, and we are genuine in our advocacy, I think the change will come. In the desert, Tan Sri, sometimes a sand dune grows around a single blade of grass.
That's a good way to end.
Thank you, Prof. That's a nice quote. I'm gonna use that as well.
Thank you.
Thank you, everybody.
That's an excellent phrase for all of us to remember. Thank you very much.
Thank you so much.
Thank you to all my dear friends in the panel, Tan Sri Rebecca, Tricia Yo, Professor Chad, Datuk Sri Syamuddin, and thank you to all the listeners. And on behalf of G25 and the Unity Foundation, I'd like to say that we will continue the webinar series because this is a never-ending topic. We might repeat the same subject in 1 or 2 months' time. And we'll see what the progress is in the country, and then we will take it out appropriately. Thank you. I think there is a big hope that Tricia's initiative will become, a reality one day. And
God willing,
that,
yes.
yes, God willing. Thank you very much, and let's all, not lose hope. Let's hope for the best. Thank you, and
Thank you,
all the best.
Tanri. Thank you, all of you.
Thank you.
Take care.
Bye.
Stay safe.
Thank you.
Thank
Thank
you.
you so
Bye,
much.
everybody.
Thank you.
Bye.
Thank you, Tan Sri.